Really excited to see. Good morning. Thank you all for joining us. We are very excited to see a lot of interest in this class. We'll get started with a little bit of housekeeping and then dive right in. We have a lot to share with you. Please note that there is a link to the handouts and information in the chat. We had a lot of emails returned to us when we tried to send out handouts, so you may not have gotten them, and we just decided we would post them online during the duration of the class today. You all are muted, your cameras are off. We are recording and we'll make this available to attendees and registrants afterwards within about a week. Please use the Q&A feature to send clarifying questions about the content of the training, and we'll also try to save time for detailed questions at the end. As many of you know who have attended our trainings before, we make ourselves available for a few minutes after the class as well, once we stop the recording. We will take attendance through the evaluation training survey. You can also verify your attendance and request a certificate. So this is something that will automatically appear in your browser if the webinar ends. We will also save the link, provide the link in the chat for you. And again, that's where you can request certificates if you'd like one for attending today. Please complete the survey no later than the end of the day tomorrow so that we can verify attendance and get all the data that we need to follow up to provide those certificates. I want to thank Mishta for sponsoring this training, actually a whole series of trainings through a very generous grant. We've been able to do deep dives on special topics like the one that we'll be exploring today, focusing on criminal backgrounds and tenant selection best practices. So my incredible team is all working hard this morning. Bree Miranda is our education and outreach coordinator that will be co-presenting with me today. And behind the scenes, keeping this all together is Lindsay Owens. They are also an education and outreach coordinator for the Fair Housing Center, and they can assist if you need anything. So please contact Lindsay. And here is all of our contact information. So we're going to talk very quickly and very briefly about what's happening with the fair housing laws in Michigan and some guidance updates from HUD. We'll briefly introduce ourselves, talk very quickly about what's happening in housing discrimination before we dive into the brand new guidance from HUD on artificial intelligence, or AI, looking very specifically at advertising, tenant screening, and then looking at criminal background screening and applications and selection before we log off for the day. So a full agenda. And so with that, we'll get started, and I'll turn it over to Bree.
Good morning, everyone. Sorry, I was still on mute. Briefly, if you are not aware of who we are as the Fair Housing Center of West Michigan, we're a private nonprofit that started in the 1980. Our mission is to really prevent and eliminate housing discrimination, ensure equal housing opportunity, and promote inclusive communities. We do this through various things. So trainings like today, we also offer other education and outreach, and we do research, and then we also do advocacy and enforcement for those who are facing housing discrimination. We cannot provide legal advice, and we have no attorneys on staff, and then any information today is for educational purposes only. So yeah, we do a lot at our agency, but we hope that we can answer any fair housing questions that you all have in general. There are additional fair housing centers in the state. So we are one of 4 traditional ones. There's also a legal services in Flint that does some fair housing as well. So these are all hyperlinked to find which one may be in your service area and best be able to help you. And then there is our little handy map. You can call our office. We will ask where you're located. It's one of our first questions we ask folks. So we may have to send you off to the other fair housing center if you are not in our service area. But we're happy to do so. So if you're new to fair housing, what is it? Fair housing is the ability to choose housing free from discrimination based on protected classes, which are under federal, state, and local fair housing laws, which we'll go over really quickly in a moment here. It also helps fair housing protects against any housing transaction. So anything that includes anything within the housing sphere. So it could be rental sales. Those are commonly, but also lending, insurance, appraisals. There's other ways that housing discrimination can occur in the housing transaction process. And so that is what fair housing can help protect against. Something to keep in mind as we go through this training, just how housing affects every aspect of our lives. You know, where you live affects how you live. So having that choice is so important. You know, the choice to your schools, health, various factors are influenced by where you live. So these protected classes that I mentioned, what are they? So under federal law, there is race, color, national origin, so where somebody is from, sex, which then also includes sexual orientation and gender identity, religion, disability status, both mental and physical disabilities, and familial status, which is the presence of children under the age of 18 in the home. There's also protected classes under HUD equal access rule. So that is if you receive federal funding, marital status is protected, sexual orientation, gender identity, and then they have a different definition of family. It's pretty expanded, which you can find in that hyperlink there. At the state level, we also have additional protected classes to the federal ones, marital status. So whether or not you are single, married, widowed, divorced, you are protected. Age, so over the age of 18 is a protected class. And then newly sexual orientation, gender identity, and gender expression. And then locally, there are additional protected classes. So you have to kind of do your homework there. And we've provided some links in this in the training to different municipal codes to find out if you have additional protected classes in your area or in the area in which your properties may be.
Yeah, so I put that slide a couple down, which really isn't the best organization. Sorry about that, Bree, but here are the links that you're talking about. And also a quick list of the many cities that logged on to the call: Ann Arbor, Detroit, East Lansing, Grand Rapids, Holland, Kalamazoo, Kentwood, Lansing itself, Traverse, Wyoming, all have local fair housing ordinances. So these are ways you can verify and find information about your Michigan protections.
Yes. And as I mentioned, there was a update to our protected classes in the state of Michigan that took place this year in February. So sexual orientation and gender identity or expression were added, and those definitions are are listed there. But those are now protected in the state of Michigan, so folks can come forward if they've been denied housing, treated differently in housing because of those things. And then we have a pending, kind of pending source of income protection. It did pass the House and it did pass the Senate. However, they kind of need to be combined and matched to be similar in what type of what they say. That they're pending right now, but this would include source of income as a protected class in the state of Michigan, and this is kind of what it kind of covers. So it would be housing assistance, veterans benefits, Social Security, any type of source of income that's legal verifiable income. And it also, there is an exemption for small landlords with less than 5 units, and housing agencies are tasked with handling vouchers within 30 days. These bills would also amend both the Tenant Landlord Act and the Elliott Larson Civil Rights Act, which is the Elliott Larson Civil Rights Act is what has our protected classes for the state of Michigan.
So stay tuned.
Yes. And then, yep, the links that Liz mentioned. And then something to keep in mind as we go through this training, there are some areas that have local fair chance, fair access housing laws. So to be aware of those kind of are criminal record related protections. So just make sure that if you are located in any of these areas, that if you do have a Fair Chance Act, that you're looking into it and that you're understanding what is covered under this. There was one introduced in 2022 and 2023 in Michigan. However, it has not gone through yet. So, but this is something to keep on the horizon, that it could be something that Michigan also introduces. And then thinking about nationwide, what does fair housing look like? So this actually was the highest when it came out, but NAFA just announced today their trends report. So last year, this was in 2022, there was over 33,000 complaints across the U.S., which was the largest number. However, in 2023, did surpass that at I had that number and then I
Just
lost
over
it.
34,000 this
Okay.
time.
Yeah. So we're continuously seeing fair housing complaints coming to the forefront. So please report it if you are seeing it.
Mhm.
And then our caseload. So we had 140 cases last year. Disability is still our number one caseload, which has been that way for the past 8, 9 years now, followed by race, color, and familial status. Um, those tend to be our top three protected bases that we see allegations of housing discrimination. Um, and disability, again, like includes both mental and physical disabilities. And then looking at our cases by transaction, in 2023, rental is heavily where we see our cases come from. However, our next class is going to be the reasonable accommodations, which we cover in some other trainings, but that is a change into policy for people with disabilities. So that is our second highest. And then you can kind of see the rest of the pie chart there. Sales follows that.
Mhm. Thank you, Bree. I'm going to kind of shift gears now towards the guidance and our main thrust of the conversation today. And I just wanted to kind of start with a framework of what we can think about and what we're asking you to maybe take away from the training. It will be recorded, so you can always refer back to it. We do have the materials online. For some reason, a lot of the emails wouldn't go through with our handouts this morning, so we sincerely apologize, but check the chat for the link to the training page. Where you can download all the materials. You're always welcome to email us, of course, individually. That might be a good way to get them as well. You can reach out to Lindsay or Bree this morning to get them if getting to the internet is not working out for you either. So appreciate your patience with that. And we know this is a lot of good information, and we love how many of you really want to have this information. So we will get it to you for sure. But, kind of backing up and thinking about the whole premise of today and the new guidance from HUD is really thinking about what do we really need to know if an applicant can be a good tenant now. We have lots of case law, new guidance, new best practices, lots of research informing this. And so we really challenge ourselves to think about the big question is why? Why are we requiring this of anyone? Why are we asking this question? Why did we put this standard in place? What is it trying to get at? Is it really something that's useful? Are we using the information that we're getting from all of our, open inputs where we're asking people to provide information to us in applications and any follow-up forms and documents? So I really encourage you to come away with maybe a fresh set of eyes to think about screening standards, because fair housing laws and HUD guidance have really moved this area forward. We're learning from good data and research to really think about what's the best way to screen tenants. Is this still meaningful? A lot of practices have been in place for decades, and things have changed dramatically in those decades. So it's really, I think, helpful to think about that big question: why? Why are we asking this? And in more detail, are we really using all the information we're collecting? Not only is it good compliance for fair housing, but also I want to highlight, if you're collecting information related to the protected classes, you really want to be careful about that. If you don't have a business justification for requesting information tied to a protected class, it can create a fair housing risk. So kind of a couple of areas to be in good compliance there. And something that we hear a lot is people say, well, this is something that's required. MISHDA requires this, HUD requires this, management requires this. And I really encourage you to verify that. Find the source. Where is this requirement coming from? Has that requirement changed? Some of you know that I've been working in fair housing for some time now, since the early 2000s. And I can safely say in the last few years, we really have seen significant changes, as I've mentioned, in case law, in cases being decided, guidance being issued, research being shared out. So it's really important, even with Michigan law changing for the first time in my tenure in fair housing, it's really important to be aware of this and make sure that what you're leaning on as a requirement is actually still a requirement. So verification, I think, is really critical. Besides asking why, then verify. So diving into the HUD guidance, which is two different sets here, just issued at the end of April. A lot of people are kind of diving in and getting their arms around it. So it is brand new, but it does build on a lot of the things that we've been looking at and talking about for the last few years. There's one set that we'll focus heavily on today that looks at tenant screening, and the other is looking at advertising of housing opportunities through online platforms that use targeting for ads. So want to make you aware of that one. We won't spend as much time on that second piece. And it's all about, modern business, artificial intelligence, using online platforms and taking advantage of the technology that a lot of people are shifting to and starting to use on a day-to-day basis. Very briefly for the advertising piece, it's looking at advertising on digital platforms. So as is often the case with HUD guidance and legal definitions, it's pretty broad. But it's important to note that this applies to advertising of housing, which many of you are going to do, but you may be also involved in credit and other real estate related transactions that are promoted online, using automated systems, using technology that has algorithmic processes behind it. So the computer machine or machine learning programmed to make decisions and do work for us, relying on artificial intelligence. That in this case is facilitating who sees ads and who has access to information that's really critical. Our housing market is still very tight. People are concerned about not having options, and affordable options, accessible options, attainable options are all included in that. So this is really timely in terms of better understanding how people get information about housing, which largely has shifted to online sources. So thinking about that is very, very timely. Ad targeting can risk violating fair housing laws and being discriminatory in a series of different ways. Some are very basic. People can't find the information, or they're being actively denied the information, even if they're looking for it, by the platform. You've heard me talk about Facebook and Meta being sued in the past as big examples of targeting. Or conversely, people are targeted or identified as vulnerable for predatory products and services. So, it's finding people that they think they can more easily take advantage of, and those can align with protected classes. Even having discouraging or deterring of potential consumers is problematic. Certainly changes in prices or conditions being changed based on who the consumer of the information is, especially if it's a protected class, is problematic, or steering home seekers to particular neighborhoods or away from particular neighborhoods. And even charging advertisers higher amounts to show ads to some consumers could be potentially discriminatory under the Fair Housing Act. So lots to consider there. Very briefly, advertisers are defined as entities, or more importantly for a lot of us today on the call, individuals who are placing ads for any one of the many, many options that have ramifications under the Fair Housing Act. So rental housing, property management services, posting ads, you are considered an advertiser. If you're putting residential real estate and related services out there, mortgages, mortgage brokers, home insurance like Bree talked about, and more. So broad definition of who an advertiser is. And the ad platform is anything that's a product or system used to direct and deliver those ads to people in digital spaces. Sometimes it's a single website or a mobile app. Sometimes it's social media or professional real estate websites, also covering, I think, a lot of us on the call today. So very inclusive in terms of who this would be applicable to. And I encourage you to dive into it and take a look. Just really quick advertising best practices, a quick reminder, really scrutinize any communications before it's published or posted. Focus on describing the property and avoid mentioning the people. Or if you are talking about the people, you really want to scrutinize that for fair housing risk. Some properties are set aside for populations under HUD programs. So even you want to be very careful about following the advertising guidelines. One of the handouts was an advertising and fair housing sheet to refer back to. Advertising also, not only includes the online communication, but newspaper ads, flyers, promotional materials, verbal statements can be included in all kinds of communications that we use today, voicemails, text messages, messaging systems, you name it. So when in doubt, take it out or don't use it, don't say it. And of course, HUD wants to see the Equal Housing Opportunity poster and logo used. So quick reminders on some of those points. We'll do a quick poll here. True or false, as long as something is part of a written policy and use at a property, it can't violate fair housing laws. So let's see. There we go. Thank you. Get that loaded there. We're going to keep this up for a very short time. These are just kind of short and sweet to help us think about applying fair housing. Let's see. So far, we have a high majority in agreement. We'll give about 30 more seconds. Okay, I'm going to go ahead and end the poll. Some of you are answering in the chat, and I appreciate that. Share our results here very quickly. You can see 91% of you said false. And I would agree with you. We've often found policies as part of investigations or seen policies as part of fair housing cases that are not in good agreement with fair housing best practices. They're outdated. They haven't kept up with current guidance. They haven't been updated in a long time, or they just, they were written with the intent to be and are discriminatory. So very important note that, as I said, you want to verify, make sure things are updated and verify what is a requirement that we actually need and is it actually still in play, up to date. Okay, so diving into the screening of applicants set of guidance. This is a second document. It's a little bit longer. I encourage you to read both of these because they really did provide them in a way that I think is more user-friendly. They provide a lot of examples, especially in the advertising one, that I think are very powerful. They always include really good data that is informative, kind of behind the thinking of some of this. So this screening guidance really is looking at how housing providers and companies that offer tenant screening services can conduct that screening in a non-discriminatory way. It includes best practices under fair housing, and it applies to all housing decisions, regardless of what technology is used. So if you're thinking, oh, I don't use a screening company, you still need to pay attention to this guidance. It does incorporate a lot of that, but it is also establishing some really nice best practices that I think are important to incorporate into your practices. It talks about common fair housing issues and ways that people can avoid discriminatory screenings. I think one of the best parts of understanding this guidance that we will look at point by point is really the guiding principles. And at their base, they're very simple. Choosing relevant screening criteria, again, kind of really focusing on what do we really need. We want to make sure people are using accurate records to make decisions, that they have updated policies that are being followed. And I think a huge emphasis on being transparent with applicants, educating them, empowering them with information, letting them know what happened in terms of coming up with screening and reports about their application, and then allowing for opportunities to challenge negative information. This is something we've talked a lot about under the criminal background screening guidance that's been out for a few years now. And then finally, if you are looking at working with screening companies, there's recommendations on how they should be designing and also testing their computer models to make sure there's good fair housing compliance. So I won't spend as much time on that 6th point, but you have all of this information in the handouts to refer to. So what's relevant? Focus on information that's tied to their ability to be a good tenant, and can they complete tenancy obligations? Can they pay their rent? Be precise. This is a theme that came up a lot in this guidance and I think is really helpful. It's a way to think about maybe being less discriminatory as an alternative. The more precise you are, the easier it is to stay in the lane and be consistent. And oftentimes it is less discriminatory to be more precise and really limit your criteria to what is relevant. They recommend possibly waiving criteria that's not relevant to the applicant's circumstances, such as, someone whose rent will be paid by a third party through a voucher, for example, shouldn't be held applicable to the minimum income standards. There's something that may be waived there, or maybe we only look at their portion of the income as a way to be equitable. It's a simple recommendation to prioritize recent records. That's been a trend across the board, really, is focusing on what has been happening recently with this applicant. There is a recommendation to avoid screening current tenants who have had no incidents. Their behavior is already being established by the fact that they have no issues in having resided there. So that stood out to me as well. They also encourage that records that don't have negative outcomes don't be used, right? So avoid those. If a tenant faced an eviction, but they prevailed, that shouldn't be considered. If the information isn't clear about the outcome, you should disregard the eviction or the information until you can get additional info, or unless you can get additional info. So again, really focusing on relevancy, narrowing the scope. There's a big emphasis on using accurate records, which makes sense. Data sets used for tenant screenings are often incomplete. They miss key personal identifiers, or they're updated infrequently. This is something that especially impacts Hispanic, Asian, and Black individuals. Records of people with the same or similar names are often erroneously attributed to the wrong person. Records should be matched using multiple pieces of information. You should be hitting multiple data points that confirm, yes, this is the Liz Keegan that I'm looking at and talking to. They discourage matching that is kind of identified as kind of wild card or name only. So not strong matches. Not sure that we have the right person. That information should not be used. So from our perspective, we have a couple questions here that might be helpful. Where's the data coming from? Is there any data cleanup undertaken? How can we show that this is accurate data? How often is data cleanup happening? How is it done? How is this information being verified as truly accurate? Recognizing that there are a lot of flaws throughout a lot of the data sets, and technology is not perfect. Some days it works really well, and some days, like this morning, we experienced barriers with it, and it's never the same thing twice. So I think it's really helpful that they acknowledge that. And encourage that people be mindful of using accurate records. When we are now having the screening occur, it's best to have a policy and then, of course, follow that policy consistently. So one recommendation is not considering records outside the scope of a stated policy. So you've worked hard to develop a screening policy, and then you don't want to extend yourself further beyond it. For example, don't consider a misdemeanor if the policy is screening for felony convictions. So in a lot of ways, this can simplify and streamline some things, which I think is an important benefit. You want to check to see if the screening company you are using is actually following your standards that you worked hard on and defined and is conforming to your policy if you are using a screening company. But this is also something that can be applied to staff. Make sure they are familiar with the standards and they are conforming to your policy. One recommendation is not to ask applicants for any history, criminal, credit, or housing related, that falls outside of your policy. Again, that can streamline your process, but it's also recommended as a best practice. Don't gather more information than what you actually need to assess whether somebody will make a good tenant. Fourth, we think about transparency. So being transparent with applicants themselves. Many of these policies are nebulous or outdated, or people can't put their hands on them. They may be being misinterpreted, so they should be in writing, made public, and readily available to potential applicants. This is a recommendation right out of the gate. Systematically giving applicants complete detailed information about screening criteria and the application process is important. You can give physical copies or provide a link to a website, but make sure if you're posting that information, it's up to date. Everyone who runs a website is guilty of this, myself included. Sometimes there's old information up there, so it's important to make sure that that information is updated anytime anything changes. Transparency is really important, so people know how they will be screened and why they were denied. It also helps them decide whether or not to pay the fee or take the time to fill out the application or not. Anytime I have an arrow here, I should have said this sooner, but we'll start to see this arrow more and more. That's something I interpret as an action item and something that might be a good takeaway to think about doing. So the bullet points are really more of a education and some of the guidance that we're pulling directly from HUD. But if there's an opportunity for an action item, I tried to switch it into an arrow there to kind of give you a quick way to refer back to what I admit freely is a lot of information. So something to consider is giving information on how to submit mitigating circumstance information. People also need to be aware that any policy that you have, not just screening, but any policy in place could be subject to a reasonable accommodation request, which is specific to people with disabilities who have a disability-related need for you as a housing provider or professional to change how you do your policies, practices, services, et cetera, in order for them to fully enjoy and utilize the housing opportunity. So reasonable accommodations can be made to really anything that we'll be talking about today, and I'll circle back and remind you of those. You also should give information to applicants about how to contest an inaccurate, incomplete, or irrelevant record. So really opening up the process quite a bit so that there's more engagement, but also more accurate information being shared and more understanding of the process. There's a specific section, and all of this is a direct quote from the guidance from HUD about being transparent around denial letters. They encourage denial letters to give as much detail as possible, give all the reasons for the denial, including specific standards where they didn't meet your policy and how they fell short. So instead of just saying, your credit history, the reason is your credit score, you were denied. The information should be, you were denied because we have a credit score of XYZ and you have a credit score of ABC, according to this service that we utilized. So they now know where that information came from, and they have an opportunity to address that with you or with the service. If they fail multiple screening criteria, all of those should be included in the denial letter, and all records relied on should be included. So they have the same information and can then verify or update it as needed. Again, instructing them on how to submit an appeal and offer that mitigating circumstance opportunity to collect more information or an accommodation if they would like to request one based on a disability and a disability-related need. Allowing applicants to challenge negative information is a theme that we will talk about throughout the session today, both in screening and the AI side of things, and also in criminal background screening. So allowing that opportunity to challenge any potentially disqualifying information or dispute the accuracy. Provide them with the information you have with the specific standards at issue. Help them understand, make it easy for them to understand why they were denied. They should also have a chance to show, even if the record is accurate, that they will comply with tenancy obligations regardless. This is a big emphasis. Again, so applying a minimum income standard requirement for a housing choice voucher is maybe not the right assessment. Maybe they can share information about attending a rehabilitation or financial literacy program, a rent right program, things that teach them how to be a good tenant. Maybe they've had a change in education or employment status since that negative report or the incident that led to the negative report. So this is the point I talked about, that if you are working with the screening company, I recommend you refer to, again, being precise can really help avoid discriminatory effects, and being aware that the data is not perfect, especially for specific demographic groups that are often tied to protected classes. Their data can be limited and is influenced by the history and ongoing discrimination, history of an ongoing discrimination. So that data is flawed. So some tools here to look at: how can we make sure the screening company that we are using is aware of this guidance, is updating their standards, and is testing to make sure this is in good compliance. Some additional considerations that I think are really important, there's 3 of them: credit history, eviction history, and criminal records. These sections I think are really interesting, and again, I really encourage you to review them. Looking at, why is this information necessary? Is it really helpful to us in determining whether or not somebody would be a good tenant? They call out these 3 areas as additional considerations, and maybe time to change our practices. Credit scores are calculations made based on a consumer's credit report that's designed to assess the relative risk of somebody defaulting on a loan. It's not about the risk that a tenant will fail to pay rent. So this has become something that is very, very common as a standard, but it does not capture anything about timely rent payments, utility or other bills being paid, doesn't collect information about payments to payday or non-traditional lenders. So there's a lot of data out there that is not included in a credit scoring process. This can create disparate impact, leaves people with a negative impact, including people of color, persons with disabilities, survivors of domestic violence, dating violence, sexual assault, all are more highly hit by these credit history requirements. And again, another common theme: overly broad screenings, not being precise, may have an unjustified discriminatory effect under credit history on these groups. So again, some questions we can throw out as hopefully helpful to think this through. What are we really trying to get at? Will they pay their rent? Is there another way that we can get at it? An alternative is income verification. There's no known studies, HUD says, that they are aware of on the relationship between credit reports and scores and successful tenancy. So that hasn't really been established by a neutral source. And often people find, and there's data to back this up, that many households will prioritize paying rent over other debts. But this is also something that is not considered in their favor. So some potential actions here is to avoid denials when credit scores and circumstances are unique to the applicant's financial background, may not have a special relevance. Like, again, that housing choice voucher, there may be a cosigner, There may have been a medical or family emergency that created or contributed to that credit score or credit history. There may have been incidents of domestic violence, again, that all influence the credit score and are things that are of little relevance or may have, likely not to reoccur. Again, allowing for that explanation, gathering that additional information, allowing a waiver for a reasonable accommodation due to disability, for example. Maybe there was a change in income due to a medical emergency, or we think about that gap between when somebody has their last employment payment and then lags for some time while they can get on to disability income. That may create an issue with credit history. Someone who is experiencing incidences of domestic violence might have noise violations as well, things to consider. Having no credit history or limited credit history is even less relevant than having a poor credit history. So if they don't have a credit history or it's very limited, what does that tell us? Admitting applicants so long as they don't have a negative credit history can be a more precise policy than requiring a positive credit history. So that was something that stood out to me as well. So again, focusing on people that don't have a negative credit history versus that positive credit history. It's a small shift, but it could be really important in opening up opportunity for more people, especially those harder hit by this credit history score report system. And automated screening tools can be programmed to rely on other available financial information as a substitute for an absent credit score. So that may be a way to introduce some equity there. Shifting to eviction history, this is most commonly marketed as a selling point for screening components. It's a very standard feature that housing providers and landlords look at. It comes from private databases from court records that are compiled by a lot of these companies. And we just have to share. Court records of evictions are notably unreliable. 22% of eviction records that were evaluated in a big study found ambiguous information about how the case was resolved, or it was actually falsely representing a tenant's eviction history, 22%. So that's a large margin of error. And again, introduces a disparate impact on Black and Hispanic renters, women, families with children, and people with disabilities. So again, these overbroad screenings for eviction history may have an unjustified discriminatory effect here as well. So potential action items: not relying on eviction records that are old, incomplete, irrelevant, or where you can find better information that measures an applicant's behavior is available. Take into account that those who have a disability, those who have been retaliated against, maybe for filing a civil rights complaint or other type of complaint about maybe the health code violation of the housing, things like that. Take into account those that have a history of domestic violence, dating violence, assault. And then again, applicants should get the chance afterwards to have the record disregarded and corrections made. Again, if incorrect information is discovered. A quick note that under the Fair Credit Reporting Act, tenant screening companies must include existing disposition information for eviction records, but we found a lot of flaws there as well. Do not deny applicants based on eviction proceedings when the tenant prevailed, a settlement was reached, or it was dropped. That was a clear takeaway there from HUD. It also recommends discounting no-fault evictions when the property was removed from the market. That's out of the tenant's control. You need to distinguish the different types of evictions and the varied outcomes. So again, gathering more information that is accurate and relevant. What do we need to know about the eviction to find out if they can be a good tenant now? Why it happened, when it happened, what were the circumstances contributing to it? What if it was long ago or the circumstances no longer apply, and they can demonstrate that to you. So again, things like those medical emergencies or people being struggling with income while they switch over to disability income, there's all sorts of things that could contribute that should be taken into consideration. Now we switch over to criminal records, and I know I'm moving quickly, but I'm also watching the clock. People who've been involved with the criminal justice system are disproportionately individuals with disabilities and Black and brown people. Therefore, again, overly broad criminal records are likely to have that unjustified discriminatory effect. So we provided the HUD guidance from 2016 and 2022. We'll talk more about that very quickly in detail here shortly, but I want to finish this new guidance from HUD as well. As a best practice, screening companies should make sure that the reports, recommendations, grades, and all the algorithms used differentiate between criminal records on the HUD guidance bases, how long ago it happened, the severity, and things that we'll talk about in a moment. And they have to exclude records that are old or offenses that aren't directly related to tenancy. And housing providers should account for those considerations when they're working with the screening policies to get them set up and when they are reviewing applications. So again, criminal activity directly here shouldn't be taken into account if it was due to an underlying experience of domestic violence, such as being forced to write bad checks or property damage that might have incurred during a violent incident. Accommodations for people with disabilities may be required here as well as exceptions to the screening policy for criminal background. Might require making exceptions to admissions policies or disregarding certain criminal records. Maybe they don't have their disability makes it now unlikely that they would reoffend, or they have past criminal activity related to a mental health disability that is now being treated. So those are examples of accommodations that might come up for a criminal record policy. There's two sections here of best practices that I just really want to make sure we quickly look at for reference. We'll look more closely at this housing provider's role, but there is a second one that is helpful if you are looking at working with a tenant screening company or you are working with a tenant screening company. We pulled out some points that I think will be helpful for you to utilize. You have to remember that housing providers are regardless, even if you are liable regardless, even if you are using a screening company, the housing provider still has that liability under fair housing. So you've got to develop your own policies and practices, make sure they reflect your own judgment for all denials. Have policies that are clear, detailed, and publicly available. Only use services that implement your policy. Customize, be precise, as I mentioned. Use caution with kind of utilizing services that are directly off the shelf that have not been evaluated, especially because we went through all the protected classes and the protected classes can change based on geography, based on timing of the law. If you get a denial, you should make an independent determination under your policy whether the information is in fact disqualifying. If it's not, you should accept the applicant and consider contacting the company to adjust those standards. No matter who finds the disqualifying info, applicants should be given the opportunity again to dispute it and provide additional information. You are ultimately responsible for ensuring applicants have that full opportunity to contest that denial. If you are looking to use a screening company, you should inquire in the ways the company how they do their screenings. How are they showing that it's non-discriminatory? Get that information, keep that information. They should be customizable. They should be frequently updated. They should be monitoring. They should look at clear and specific reasons being provided for denials, allowing people to correct those inaccuracies at the company and with the housing provider, publicly disclosing information. There's that transparency again, and making sure they're complying with all the laws that you need to comply with. This is the tenant screening company section. So I'm just going to highlight that they should be transparent as well. They should be doing the same monitoring. Here's where your list of applicable protected classes come into place. So there's a couple more slides here about how the technology might be impacted by trying to be in compliance. And so hopefully these will be helpful for you to look back at, again, if you are looking at working with or are currently working with a tech screening company. So they have the same responsibilities, accurate data, making sure there's no discrimination happening. They should be using your preferences, your policies. They should not be making decisions for the housing provider, et cetera. So there's a whole section on all of that. And again, allowing for those disputes, corrections, really important from the screening company side of things, kind of focusing more on the individuals today. So very quickly, a poll here on whether or not somebody can be found liable for a violation under fair housing, even if they didn't intend to violate the law. We're going to do a lightning round here, about 30 seconds to answer this one. We have a lot of agreement here. So far, I should say. Okay, I'm going to end it and share it. So again, 94%, a high amount of agreement. Yes, a person can be held liable under fair housing laws even if they didn't intend to violate the law. So appreciate your time on the training today because this is true. Thank you for taking the time to think about fair housing and best practices in this important area. So we're going to talk very, very briefly about the criminal background screening, but all of these pieces of guidance are linked here for public housing agencies and then for the rest of the private market in 2016 and 2022. HUD is looking at updating the public housing agency guidance from 2015 to come into alignment with all of this new stuff. So they proposed a rule that was open for comment that closed on June 10th. Looking at reducing barriers to HUD assisted housing specifically. So things are continuing to change. These are the mandatory bans for public housing agencies, housing commissions, and project owners only. There's some hard and fast rules here, convictions of manufacturing meth on federally assisted property, someone subject to a lifetime registration for a sex offense, currently users of illegal drugs, abusers of alcohol, and any pattern that's interfering with health and safety, peaceful enjoyment, or anyone within the last 3 years who's been evicted from federal housing for drug-related criminal activity, unless they've been into a rehabilitation program, or again, those circumstances no longer exist. So those are must denials. May denials are a little more open. It's may consider denying admission, eviction, or termination of the lease for drug-related criminal activity, violent criminal activity, and again, other criminal activity that would adversely affect health, safety, and the right to peaceful enjoyment of others, including staff. So this is a more gray area here, and this area should also be looked at in light of what HUD is proposing for the new rule, because it will be kind of in line with what we're talking about next. There is no requirement to have a one strike rule. That's a little bit older of a belief. Hopefully it's not still out there circulating, but that's something that we occasionally do here. PHAs do have discretion to deny, evict, or terminate based on certain types of criminal history, but they have to evaluate seriousness, effect on the entire household, what they've done to mitigate that activity, and again, participation in rehab programs. So this is the current applicable 2015 guidance, but just be on caution and notice that this is being evaluated and will be updated. For 2022, HUD has put out guidance for the rest of the housing market. So that first set was only for public housing agencies. It encourages people to consider not using criminal history at all because it's not a good predictor of housing success. So there's lots of examples throughout this guidance. I encourage you to take a look at it. A lot of it is very basic for housing information. You've got to tell people what your policy is, and you've got to apply it across the board, regardless of race and any of the other protected classes. Couple examples here that we've shared before, so I'm not going to spend too much time on them, but they indicate that people who are already living somewhere are also protected. So evictions have to be evaluated with a fair housing lens, as we've talked about now, based on the new guidance. And also doing screening after learning somebody was hospitalized for a mental health condition would be a violation of this guidance as well. So our fact sheet has all of the best practices from 2022 compiled into both procedures, which we have here. A lot of these are very similar to what we've been talking about with the updated screening guidance. This is the foundation for this 2024 guidance. So there's a lot of cross-referencing and building on that. So here are some active steps that people can take to put into place about criminal history. A lot of it is getting your policy in place, communicating that, making sure you're in compliance with federal and state laws, avoiding third-party screening companies that you haven't been able to verify are not using biased algorithms. So now we have all those steps about how to do that. So full circle moment here with HUD. Further procedures, allowing for that individualized assessment is critical. That was outlined repeatedly now in several pieces of HUD guidance. Not evicting people who have been victims of crime, only evicting for criminal activity as a last resort and after gathering that actual data. Don't ban tenants' guests based on the guest's criminal involvement, and document all screening decisions made, circumstances considered, all the information that you gathered. What we can focus on is the nature, severity, and recency of criminal conduct. That has been very clear across multiple pieces of guidance. It's all policies focusing on convictions that demonstrate risk to resident safety and property safety. So homicide, sexual assault, and arson can be tied to resident and property safety. You want to differentiate between criminal conduct that does not, gambling, prostitution, tax crimes, etc. Blanket bans have been successfully struck down since 2016. No felonies policies are no longer defendable as non-discriminatory. You have to consider convictions and not just arrests. The individualized assessment piece is critical, as you've seen me mention it several times today. You also have to consider accommodations, again, for people with disabilities making requests to these screening policies. So what are some of the common issues and risks for tenant selection and criteria that we see? An extensive list of convictions, many of which are unrelated to property or resident safety. Broad categories, overly broad. You've heard me say it several times this morning. So being less precise, convictions related to family relations, government, public peace. What does that mean? How is that tied to property and resident safety? Vague language may be denied if a felony is evident. Well, what is the actual policy on that? Not defining the type of the crime in the policy, having lifetime or unreasonable look back periods. I saw a case the Equal Rights Center had with a housing choice voucher screening, and they went back beyond 3 years and 7 years. So we're starting to see, case law and recommendations we can look at. Not allowing for that individualized assessment is a very common issue. So that is something that has to be updated. Here's a link to information on criminal history in the LIHTC compliance manual. We also have the HUD handbook. We can share those links with you. The PDF of the PowerPoint should all have clickable links, but if it doesn't, let us know. This allows for owners to have discretion, but I would encourage that all of that be updated with all of this new guidance that we are seeing. I'm going to skip this poll real quick. And let me just tell you, keep your records for at least 3 years. That's the answer to that one, because I want to make sure we have, we can look at questions too. Applications should only collect information that's relevant to good tenancy. Do they qualify? What are we collecting there? Make sure you're not asking unlawful questions in person or on the application. Review the information that you're collecting and make sure you're using it. I talked about that before too. If you're collecting information, especially in regard to protected classes, the burden could shift to you to show how the information collected didn't influence the decision and the housing access for that individual. So especially if you're not using it, you should not have it. Congress has set forth some guidance, and there is some HUD guidance in the regulations about how we can address blanket inquiries. You can't ask overly broad questions about the description, nature, or severity of a disability. That changes when an accommodation or modification is made. You can't ask the applicant or tenant to waive the right to confidentiality about their medical condition or history. There are more standards there listed. You've got the link there that kind of helps wade through what can we ask, and I recommend you check that out. Other plan or criteria, common issues or risks. Outdated list of fair housing protections. You've got to get your fair housing list updated. Make sure it's then embedded across all of your policies, documents, and communications. We see outdated plans online, as I mentioned, or they're given out and they're outdated. Sometimes the practices that are actually being used at the property are different than the plans. That actually can be a good way. They're actually more inclusive and operating correctly, but the plan is discriminatory and vice versa. So make sure those are up to date, available, and accurate. Having incorrect or narrow definitions, more narrow than federal law would allow or state or local law would allow. So a very narrow definition of who is a family with children, for example, or using unreasonable, outdated, or blanket occupancy standards in tenant selection and other plans that don't take into account the size of the unit, the layout, or the bedroom size. So we see that 2 heartbeat per bedroom, 2 people per bedroom standard. That may work with older properties that were built when that was very standardized cookie cutter housing, but often it does not work in different types of layouts, townhomes, the way that we build now. So it's really best to update that policy. And I encourage clarity and readability or ease of use for the public and for staff. It will help with consistency if people can understand it. Some best practices include all the criteria used in your decision-making for your tenant selection documents. Be specific. It should be written and accessible. It should lay out your appeals process, state the right of a person with a disability to get that accommodation raised. It should include a non-discrimination statement. Other best practices, have your list of protected classes. Do a side-by-side comparison. Would anybody be treated differently based on a protected class? Can we identify any potential negative treatment unintentional barriers. Who are we leaving out? Are we allowed to leave that population out? Can we verify that? Can we find the source? How would you defend any findings as non-discriminatory, and how would you prove that? Where's your evidence? So hopefully these are helpful kind of questions to think this through as well. So we have tons of MSHA resources linked here for you, tons of tools and resources on our webpage included in your handouts. You can find it on our class page today only for the class today. We'll follow up with a video for you. And I'm going to take a look at some questions. Maybe Bree, if you can kind of help me wade through so I don't miss any. But this is the survey that we talked about, where we would want each individual to take the survey and request a certificate individually. That helps us because we've got probably well over 300 on the call today. So let me dive in here to look at some questions.
Yeah, Liz, one question that we had, I had to get some clarity on, so I wanted to
Yes, thank you.
make sure you don't miss that. Somebody did have a question in regards to the PHA criminal background, and could a tenant be denied for guilty of a DUI, a DWI, or OWI type of offenses under PHA bans? What was that question?
I think that is a good question. And I think we would want to get more information. How long ago did it occur? Is it recent? Have they graduated from any rehabilitation program? So I can't give a blanket yes or no. That's a fine decision to make. And I'm practicing what I'm hoping you will practice, is we have to gather more information. We need to know what the policy is. We need to know the recency, the severity, and things like that. And then we want to compare it to the applicable PHA guidance. I also would recommend checking out the PHA proposed rule so that you're prepared for what sort of changes may be coming. And hopefully we'll continue to get grant funding to focus in on more of those proposed rules, or when they go into effect, to dive into those things a little bit deeper. But we can't make that determination quite so simply. We got to practice what we teach. And then I see a question about HUD having a guideline scale of issues with people who have a history of being a victim but non-compliant with PHA housing rules or paying rent. So I think that again would be a situation where you gather as much information as possible, verify its accuracy, look at how recent that behavior has been, and then you have to kind of sort through and figure out whether or not they fall on the line of, is this somebody we believe would be a good tenant or would not be a good tenant? But I would apply all the standards that we've been thinking about and talking about today. And allow for that exchange of information, gather the documentation that you invited more information to be provided about those mitigating circumstances, and maintain that documentation that shows how you made your decision.
Somebody had put in the chat, basically most concerns are a case-by-case basis, and I want to say, yes, that is true. You have to evaluate.
We would evaluate applicants on a case-by-case basis. So yeah, a really good point. I appreciate that so much. We want to have our standards, and we want to do our cross-reference with each applicant. Yeah, absolutely. Some will be very simple, I think, and straightforward, and some will not. So yeah, really good point there, and much shorter than what I said. And again, it's really hard for us to judge individual cases on a couple of small points. I think this guidance is brand new, and we'll be looking at credit score, and we may see case law come out of this, further guidance that says, really strongly discouraging credit score use. I think the message was pretty clear that that's a direction that HUD is recommending. So unfortunately, we can't say yes or no, that's fair based on a small amount of information, and also not knowing what the policy is. Conflict of interest policies, I think, are probably almost always a good idea, but that is probably something that needs to be verified with MSHA rules and other regulations that we wouldn't be as familiar with. So I think that's also something that would require a little bit of homework, and I would always get those answers in writing if you can. I saw a note about saying some observation about strain on landlords, especially coming out of the pandemic. And it's, I think that situation really informed a lot of the work or pushed the work going on about researching evictions and the impact that has on housing access a little bit forward. So I think in order to be in compliance with the HUD guidance, they are saying, yes, you have to look deeper into the possibility of what the circumstances were of the eviction history. That's where this guidance seems to be going. And I think there's a question about warrant requested outside of the term limits. I think what I'm understanding from that question is if it's outside of the scope of your policy, then it's information that shouldn't be considered, but I may be misreading that. I think there's probably also questions in the chat maybe that I'm also not keeping up with, but I want to thank you all for being on the training. If you have time to stay on, we will continue to try to answer some of the questions that are coming in. But if you don't have questions, I appreciate you being here. Please click on the link. Please look in your browser for the evaluation. We will want to make sure that you provide that information to us so we can get certificates out to you within a few weeks. It will take us some time. We had hundreds of people on this class and we've been training lots of folks lately. So please be patient with us. We'll also get you the video. So thank you for joining us today, and we'll stay on to keep answering some questions.